Majority Leader Dugan, thank you so much for joining us. If you want to step up here, do you want to say anything? I'm good. Okay, have we done okay so far? All right, thank you, thank you. We have sign-up sheets up here at the table for the three bills that are in committee today. There was a sign-up sheet for Senate Bill 359 at the last hearing, but please come sign up again if you want to be heard on that bill. Anybody else need to sign up? All right. Before we start, I will ask Senator Watson if you'd like to open us up in a word of prayer. Which mic are you? 12?
Yes.
All right.
Let us go to prayer. Dear Lord, thank you for looking over us and continue to look over us in our travels and our deliberation, and let us do your work. In Christ's name I pray. Amen.
Thank you, Senator Watson. You're optimistic that you're up first, I guess. I think it does make sense. There were some changes there. No, yeah. That's how you got so far in life, was alphabetical order, but it's different around here. You have, I think, an amendment that you wanted to offer today, and so I think we'll start, if you want to come up to the podium, to the table, and we'll start by letting you talk about the amendment that you have. Everybody should have a copy in their folders. The Senate Bill 359, working off LC 490788S. Senator Albers.
Thank you, Mr. Chairman, and thank you again for allowing us to come up here in the poll position. I have brought Mr. Mike Carlson again with me. If you'll remember, he is the Executive DA for Major Crimes Division under our Fulton County District Attorney, Fonnie Willis, who is here and joining us today and would like to speak as well. The amendment in front of you does three things. I'll start from the bottom because it's the most simple. It just simply says in Section 11, the traditional effective date. Make sure that it captures all parts of this bill. So you'll see Sections 3 and 6 will become effective on July 1st, 2022, and shall apply to all offenses committed on or after such date. So then Section 4, 5, 7, 8, and 9 would also be congruent with that. Pretty straightforward language just to make sure that we covered all areas of the bill. Section 2, this is a very simple change on line 90. We just change any to A, pretty much a Scribner's error. And then we'll go up to Section 5, which is the larger part of the amendment, and I'll direct you to beginning on lines 119, which should be on page 6 of your bill, at which point we're going to strike those 4 lines, and we're going to replace them with subsection A, B, and C here, and I'm going to ask Mike just to briefly take you through that, if you would.
All right.
Yep.
Thank you, Mr. Chairman and members of the committee. We have with us also today to help explain these changes, John Floyd, who is a partner with the Bondurant, Mixon, and Elmore firm, a nationally recognized racketeering law expert, also an expert on our state gang statute, as well as serving as a special assistant district attorney in our office. Essentially, we looked at several ways to potentially improve the draft for 1615-2, which is to create a Street Gang Act venue provision that would correspond with the one we have for Georgia's racketeering laws, and which has been successfully applied through our appellate courts. So the first iteration of that was to change some of the ending language to more closely correspond with the gang statute, and then in subsequent work with Mr. Floyd and others, we created the 3 tiers here, which connect in Section A with the venue being where acts of the gang operating would have occurred, because those are criminal acts under the gang statute there. Subsection C of the gang statute, which corresponds with subsection B here, pertains to when property is acquired through criminal gang activity, and so venue would be placed where that property may be. And then lastly, the sections or the subsections of the charging provision of the Street Gang Act that are listed there in C pertain to various sorts of threats. So venue is thus connected with where those threats were communicated, received, or where the person threatened resides, or where property of any person threatened is located. So those are the fundamentals there. Mr. Floyd could also speak to this if the chairman would like to call him up now to address any questions.
Well, let me ask this, and if he has answered this, he can come up. Under A, where we talk about for the venue for subsections A, B, D, and E, we say in any county in which the criminal street gang with which the defendant is associated operates. How do we define operates?
The way the Supreme Court has approached the definitions under the Street Gang Act and constitutional challenge to it is to apply essentially a standard definition to it. The word operates appears in the Street Gang Act. So where the not only where the gang might be committing criminal gang activity per se, but just maybe resided, housing, recruiting, and that's a note to point out now that recent article said that over 400,000 children are recruited into street gangs annually in this country. So wherever a group fitting the statutory definition of criminal street gang under our law would be, again, committing criminal gang activity, but also operating in other ways.
And so is operated, is that defined there in that section? Because I didn't know if operates means you had to have some sort of crime that was committed, or if there's a meeting with gang members, or what? How do we define operates?
Yeah. Operating, it would just be, as interpreted, it would just be any operation that would be in furtherance of the gang.
Okay. Is that tight enough language for someone to know where a crime is being committed?
We had when the constitutional challenge to the Street Gang Act, which Mr. Floyd and I argued in front of the Supreme Court together, there were questions about those kind of definitions and notice, vagary, ambiguity. And for any definition, I can't remember specifically what the terms were, but the Supreme Court went to just standard definitions and utilized those and applied them to find the act constitutional unanimously.
Okay. Do we have any other questions for Mr. Carlson or Senator Albers at this time about the proposed amendment? Or any other questions about the bill while they're up here as well?
And I believe Mr. Floyd has signed up, so.
Okay, yeah, I can call him up. We have a question from, is it Senator Tillery?
Yes, thank you, Mr. Chairman. We're on LC 4907S88S, right?
That's correct.
That's right. I don't know if it's a question as much as a comment. In Section 2, I see when we're dealing with the accountability courts, if I'm correct now, every single circuit has an accountability court now, right? Have we reached to that point?
I believe so.
So
I'm not 100%
if we're
sure.
there, then I think the accountability courts used to be different. But now if every circuit has an accountability court, all we've done is just create another council. So I'm not doing anything now except just making folks aware that are watching online or here that at some point in time we need to consider rolling that into the Superior Court Council if every Superior Court has an accountability court. There's no reason we should pay twice.
Senator, I agree with what you're saying. It makes perfect sense. And not to reiterate what I mentioned in the hearing yesterday, but our accountability courts are doing a phenomenal job. And I mean, I've always challenged everyone who's not been there to go to one of the graduations and not have a tear in your eye. That being said, even though I believe that most all of our judges are wonderful, we do have some that wanted to be both legislators and social workers. And we have seen some very violent criminal acts be sent to an accountability court that should not necessarily have gone there, should have stayed with the Superior Court. So this is not to impede what they do, but to put some accountability to the accountability courts.
Any other questions for the author or for Mr. Carlson from the committee? All right, thank you. We will go ahead and call up Fulton County's District Attorney, Ms. Fonnie Willis. Appreciate you joining us this afternoon. If you want to come on up. And we're back at a posture of testimony on the bill, and of course, anybody wants to comment on the proposed amendment as well. Good afternoon.
Good afternoon. Happy to be here today. I really just want to thank you all for taking the time to consider this particular legislation. I think it's extremely important, not just for the urban district attorneys who are in more populated communities, but for all of the district attorneys. We each are faced with criminals that, you know, are just repeat domestic violence abusers. That one really hits home with me. I lost an aunt to domestic violence, and so that's a subject that I know hits so many families. It doesn't matter what economic status you are. We know that people are impacted by that, but also that this would assist crimes against children, elder abuse. It is just a statute that is very well encompassing and will help prosecutors across the state. And so I only wanted you to hear from me today to know that I'm fully supporting this. I think that it is awesome how many people have signed on and believe that this is important legislation. And I wanted to be here so that if there were any questions that needed to come from the district attorney, I realize I have the largest district attorney's office because it's needed in the largest jurisdiction, and unfortunately we see the most crimes. And so this bill assists my prosecutors and really more importantly, the community in so many ways.
Appreciate that, and thank you for your office's work on this legislation. It's great to get to team up with you guys. We obviously need your guidance on stuff like this. I appreciate what you're doing. Any questions for District Attorney Willis from the committee?
Well, you are
All
the
right.
easiest crowd I've had recently, so
give
thank you.
us some time. We're just getting warmed up.
Well, thank you. I think you will enjoy speaking to Mr. Floyd. I've worked for him for many, many years. We can't seem to snatch him out of private practice, but he does come and help the DA's office quite often, so please feel free to ask him questions.
Awesome, thank you. Well, with that segue, I will call Mr. John Floyd up to speak as well. Thank you for joining us.
Thank you, Mr. Chairman. Mike Carlson did a good job of describing how this amendment came to be, this proposed modification. You asked a question, I expected we'd hear this, about the question of operating and whether that's precise enough. So that word comes directly out of the General Assembly's statement of findings and intent that are the preamble to this statute. And they specifically expressed a concern about gangs operating in the state of Georgia and what happens when they do operate. The normal analysis in our appellate courts is if a word has ordinary significance and it is not separately defined, you just apply the ordinary significance. So I checked Webster's this morning. Operate is to perform a function, to exert power or influence. That's exactly what these gangs do. And one of the things that is an objective here, as it was in RICO, is that a gang by its nature is kind of a special kind of criminal conspiracy. These are criminal street gangs. I mean, the word criminal is in the definition. A person can't be liable under the Gang Act unless they are involved with a criminal street gang. And so that person has made a choice to join this particular kind of conspiracy. Under normal conspiracy law, Georgia, nationwide, if a person joins a conspiracy, they are subject to being tried any place where any member of that conspiracy commits an act in furtherance of it. So we're not doing anything radical or unusual here, but because the conduct here is so varied, I mean, we had a graphic example of that, unfortunately, yesterday here in Atlanta, but it extends in my experience, in a dozen different district attorneys' offices, and particularly now in Fulton, we have white-collar crime, we have human trafficking, we have drugs, we have the acts of violence. Some of it is fairly sophisticated fraud. It evolves, it modifies over time. But the point is to not have these in a situation where they have to be prosecuted piecemeal. And if a person joins that group, and they're part of that operation, it is entirely fair, appropriate, and efficient that they should be charged where the group they work with goes. And that is what we're trying to accomplish here. I know yesterday there was a comment about forum shopping, and I didn't fully understand it, but the fact of the matter is I don't know of any competition between DA's offices to bring gang cases. They're hard, they're complicated, they require some specific training. Mike and I have been working on these together for 25 years. And so it's not as though there is some wheel that everybody's plucking cases off. It's harder to get folks to do them than not. But where there are DAs that are ready, willing, and able to do them, it should be facilitated because it's essential that this work be done. The gangs shop. They shop for victims. They shop for witnesses. They shop for opportunities. It is not fair to hold them responsible where they engage in that shopping.
All right, I appreciate you coming and giving your expertise on this. Any questions for Mr. Floyd from the committee? All right, thank you.
Sir.
Next, we have John Melvin with the GBI.
Senators, it's a pleasure. I'm Assistant Director of the Georgia Bureau of Investigations and have been for 2.5 years. Prior to that, I was a prosecutor for 25 years, worked hand in hand with Mr. Carlson and Mr. Floyd. We did what we have referred to as best practices, where comprehensive indictments against the gangs were actually utilized, and we found that when we utilized them both in DeKalb County and in Cobb County, we saw the incidences of gang violence actually go down. And so I'm here as a representative of the GBI to be in full support of the venue provision that is being offered up as an amendment, as well as Senator Albert's bill in total. Senator Kirkpatrick, I'll note that in your jurisdiction, you have a phenomenal prosecutor in Ms. Wallace, who has effectively utilized RICO. But she has gang problems up there as well. And if we can modify this venue statute for the Gang Act, then we can do great things across the state. And I've seen it done firsthand when it was utilized in conjunction with RICO. And now we can just do it with the Gang Act. And you'll give us the appropriate nuclear bomb that we can use to take out the bad actors.
Thank you, Assistant Director. Any questions for Mr. Melvin? All right, thank you.
Appreciate it, sir. Thank you.
We actually have Judge Burt Guy with us again today, guest judge from down in Brunswick. Thank you for joining us. You didn't sound to be heard on this bill. You want to be heard on this one as well?
No, I'm here. No, yeah, I'm here.
I was making a joke.
I'm here.
I was just making a joke, giving you a hard time, but.
I was actually a victim of gang violence myself about 2 years ago.
Well, we do have another judge in Fulton County, another judge with us from the Northern District, I believe Dawson County, Judge Kathy Gosselin. Is she with it? There you are. And you are signed to speak on this bill.
Yes, I am.
Am I right? This Dawson County, is that what?
Well, it's Hall and Dawson. It's the northeastern.
Hall and Dawson, Northeastern.
Gainesville and Dawsonville. Thank you, Chairman Strickland and other senators, some of whom I've seen for many years up here. Thank you. I do want to talk about the first part of the bill, which is about Council of Accountability Court judges. That's why I'm here. I've been a judge for a mental health court, presiding over a mental health court for almost 20 years now, and was last year's chair of the Council of Accountability Court judges, and I have Taylor Jones, who's our executive director, with us. I'm sorry that Scott Smith couldn't be here. He's a judge in Bartow County. He's our current chair. And he is a former district attorney, so he brings a little more weight with him when he comes, maybe. But he's busy doing court, and so I came. I do want to speak. I appreciate the folks that said nice things about accountability courts yesterday, and we appreciate Senator Albert's continuing support as he has given it to us over the years. But I did want to take the opportunity to mention a couple things and then give you an opportunity to ask me any questions about how accountability courts are run in this state. So, two things. First, the Council of Accountability Court judges, part of our responsibility is to provide accountability, guidance, and we do that through state standards and certification. There are a number of standards that programs have to meet. They have to be certified every 2 years. Every 2 years they have to be recertified. And there is quite an extensive process to do that. One of the things that happens when you're certified is you have to make sure that your team includes both a prosecutor and a defense attorney. So there are prosecutors on all the teams that work with accountability courts. And those prosecutors act as gatekeepers for those programs. So we expect them to be vocal and express their opinion about what's going on. There are other aspects to certification that we can talk about if you want questions about that, but it includes extensive and rigorous training. And if the bill is passed as it is, then we will be glad to submit all those reports every year to all the people that are listed in the bill. The other way that we assure that accountability courts are doing what they're supposed to is through peer review, which was established when we first started. And that is a team of trained individuals who are involved in an accountability court. Usually it's a judge, a coordinator, and a treatment provider. And they go and they review another program. They spend a day and a half collecting information, watching court, watching staffing, interviewing all the team participants, interviewing participants, and then give a report, give recommendations for things that might need to be changed. And then there's a process for back and forth to get the program sort of in line if there are some issues. So those are the ways that the council really handles accountability. There are a lot of rules that we have now recently enacted that are associated with the standards and certification process as well. The other thing I wanted to talk to you briefly is just the eligibility of participants for drug courts. Drug courts were not intended to be for folks with serious violent felony histories. That was not the intention. And I talked to my drug court judge, who is Judge Deal, who's been doing it for probably 15 years, and asked him if he had ever seen a serious violent felony like an armed robbery in his drug court, and he said no. So I just wanted you to hear that. The intention is to deal with folks that have drug problems. A lot of them probably have charges in the property crime area because of their substance abuse. And so I just wanted to give you that information. We have statistics about all that we'll be glad to provide if you want it, but I wanted you to have an opportunity to ask questions if you have some.
All right. Thank you, Judge. You do have a question from Senator Watson.
Yes.
Thank you for being here. Appreciate that. So how pervasive are accountability courts throughout the state of Georgia?
There are accountability courts in every circuit now, and we have how many total?
170.
170, but that includes drug courts, adult felony drug courts, mental health courts, veterans courts. It also includes DUI courts, family treatment courts, which are in juvenile court, and some other sort of random juvenile court, drug courts, mental health courts.
So are we closing the gap for areas? Are there areas of the state that don't have accountability courts?
There are no circuits that don't have any.
Right.
There are probably some areas of the state that have fewer than others.
Are we closing those gaps that may have fewer than others? That's,
Well,
I
it
guess.
depends on funding.
Okay.
So,
All right. So there we go. I'm just looking around. All right. And I had one more question, Mr. Chairman, to follow up. And it may not be your question. The venue. So if we're dealing and prosecuting gangs, and part of my concern is the witnesses that may be threatened. And I know that's a sensitive subject. Is that a reason to change venue, or does that ever happen? How do you protect the witnesses that may be threatened by gang prosecution?
well, it's a little out of my league because in Northeast Georgia, we've probably had 3 gang cases that have gone to trial. And we have gangs, but it's not our usual. Let me just say that. So I don't know that I'm the person to ask about that. Sorry.
All right. Senator Calzert.
Thank you, Mr. Chairman. Judge, welcome to our
Thank you,
committee.
Senator.
I was saving this question for a trial judge like yourself. There are provisions here for certain video conferencing proceedings, and I'm seeing those done with more frequency, and some of them I'm real excited about. If it's a status conference or a calendar call or even a pretrial conference, that saves me from
Yes.
driving to Dawsonville to see you. But I worry about evidentiary hearings. The way I read this bill, you can't have a trial by video without the consent of both parties. But what about these hearings where witnesses are testifying? Do you believe that can be adequately handled via Zoom?
Gosh, well, we've been doing it for 2 years in some cases. I do understand, and I came to talk about accountability courts. I did read the bill, so
Yeah.
I am familiar with some of the other provisions. The video provision would depend on what the evidence was, I think.
Yeah.
I think many of us thought when we initially hoped with the Council of Superior Court judges that the rules would allow video conferencing in some areas. That, for instance, if you're in a jury trial and both parties agree that the crime lab expert could testify via video, that would happen. But I think the bill precludes that. So, and that was just a convenience for the crime lab, and it's very hard to get them, and it's very hard to, so.
Okay, thank you.
I hope that answers your question, Senator Cowsert.
Senator Jones.
Thank you, Mr. Chair. Thank you. My question, a two-part question. Number one is, you can go generally or specifically as you may like. What kind of current guardrails exist within the accountability courts to make sure that persons are good candidates for accountability court? And then secondly, does the accountability courts now kind of give an impact statement, for lack of a better term, of how they're performing wherever that may go, even if they're just keeping it up for their own county commission or however that may work? If you can kind of go into those for me.
Sure, I'm going to go into it a little bit, and then I'm going to let Taylor talk a little bit about it too. The team process, when there's a referral made, and our referrals mostly come from the jail, the public defender's office, and the district attorney's office itself. Sometimes it comes from families. The referral is made, and then there are some procedures that happen first. First, is the person eligible legally? So is there a charge that would keep them from doing it? And that's where the district attorney's office or the prosecutor that's involved in the team would have a lot of say in what's the situation with that person. Do they have a long history? Is it a violent charge? So they would speak about that and say, we just don't think this person is appropriate. And then for some courts, like mental health court, then there's a clinical assessment that's done to see if they have a severe and persistent mental illness as well. But there are also assessments for substance abuse for drug courts. So there's a clinical side to those assessments too. And then it's talked about in the team, and the decision is made. And then Taylor can talk to you about how some of the folks, how we do our reporting and the reporting that we do statewide.
Sure. So part of certification and standards and grant special conditions for our accountability courts, they were required to report data to the council office every quarter. It's about 120 separate pieces of data that they're collecting per participant. And in between fiscal year 13 and fiscal year 19, Georgia's accountability courts have served 24,087 participants. And we added 2,586 in FY20 and 2,603 in FY21 for a total cumulative amount served since fiscal year 13 of 29,276 Georgians through our programs. So that data is reported to us. They're reporting things like number of drug screens that have been performed, the positivity and negativity rate of those, how many times they've interacted with the judge, how many treatment sessions that's been performed, how many surveillance visits have been performed by local law enforcement to do those home checks and those work checks, various pieces of data that's coming to us.
It's a huge
every
amount
quarter.
of data that comes in.
We collect that at the state level, and then we provide actually a statewide report. I have some copies with me today if anyone's interested in seeing that. And then we also provide per court reports back to each individual program to use at the local level to talk about their program. So that's just a little bit of the data reporting that we do. We also do statewide recidivism reports every 3 years with Applied Research Services and have some good rates there as well. Thank you.
Senator Hatchett.
Yes, Mr. Chairman. And this question may be, I may need to direct it to someone else. I know y'all are here to talk about the accountability courts. I've actually got a question about the jurisdiction issues in Section 5, so I may hold off until another witness comes up that can address that instead.
Yeah, I mean, I can look if you want me to try, but I'd be punting, I think.
I won't put you under the gun.
Thank you, Senator.
You're welcome.
All right. Thank you, Judge. I appreciate you being here with us.
Absolutely. Thank you for the opportunity.
Next, we have Bob Bray with the Council of State Court Judges. Good afternoon.
Good afternoon. Thank you. Chairman Strickland, members of the committee, my name is Bob Bray. I am the Executive Director for the Council of State Court Judges. We had a lively discussion with a group of our judges earlier today, and we have two concerns with the bill, and one deals with Section 7. And I have an older version of the LC, but I think the numbers are pretty close. Deals with lines around 202 to 204, and it deals with the requirement for pretrial reading motions and orders before the trial. The concern that came up with this particular section is that in our state courts, almost 40 of our state courts are part-time. What I mean by part-time is they are part-time judges, and then they're also attorneys that practice law. And in those counties that have part-time judges or part-time state courts, they're usually in the rural section, so they don't get a lot of budget support from their county. So when these types of cases come before them, they're going to end up doing all their own legal research. They don't have the advantage or the luxury of having law clerks like in your metro counties. So they're going to be spending a lot of time going through some of these matters in the pretrial for them, if this is what is anticipated in this particular section. The other discussion that they had today was in Section 9, and it deals with what Senator Kauser kind of referred to with the video conferencing. And specifically, it's around lines 274, 275. The Council of State Court Judges and the Council of Superior Court Judges are in the process of trying to create a new uniform rule that deals with this, 9.1 and 9.2. And they've even been working with members of the Supreme Court to try to craft this correctly. This, first of all, would codify some things that might really be better in a uniform rule. It gives the judges more discretion. They feel like if you codify this particular area, it might put a hamstring on some of the things that they look at. The other thing it says here is that no trial shall be conducted remotely. And I think you heard in the Chief Justice's comments this morning in the State of the Judiciary that he made comment to Fulton County, which was able to, in a civil case, handle voir dire by remote proceedings. And so the concern is, does this mean all trials, or do they mean just jury trials, and what does that mean? So we have some concern with the way it's written. And then again in this, it says that nothing in this code section shall limit or prevent Uniform Superior Court Rule 9.2 from being amended or modified as authorized by law. But that's pretty specific. And it seems that maybe that should be drafted a little bit more broadly to include all rules. Those are my comments.
I have a couple questions on that. On the first point you made, wouldn't the motions in limine be a way to actually help a judge that may be part-time, but doesn't have the resources to have issues raised in advance of trial? I mean, wouldn't that be the opposite of the argument you made?
It seems that way, but I was a law clerk, and I handled motions in limine for an Atlanta court, and they are exhausting to read. They are long, they're huge, and most of them are not even on point. But you have to do the research and look up the cases and the statutes to determine what they're trying to get to. And if you're an attorney that is trying to practice law and you have to go through all that stuff, it can be a burden.
But the alternative would be to have to go through that on the fly at trial, though, right?
Mm-hmm.
Your other question on the trials, the way I understand the bill, on civil trials, if both parties consent, it could be done remotely, but criminal trials would be prohibited from being done remotely. Do you know if we've had any criminal trials, you may not know this, or somebody else in the room knows, if we actually conducted any criminal trials remotely the last 2 years?
I'd have to check and get back with you. I think we've had pleas. I don't know if we've had bench trials, but it's possible that we've had.
I think we discussed this last year, another bill, the concern being in a criminal trial in particular, never being able to waive the right to confront a witness directly, in person. I think that was the concern that was raised. I was wondering if we've actually tried that anywhere, if that was considered even constitutional. But
all right, I'll
any
find
other
out.
questions for Mr. Bray from the committee? All right, thank you.
Thank you.
Next, we have Jill Travis from Georgia Association of Criminal Defense Lawyers. Good afternoon. You brought your book. What does that mean?
That's just in case I have to refer to it.
Everybody's grumbling now.
Good afternoon, members of the Judiciary Committee. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I'm sliding in for Maisie Lynn, who is not able to be here today. I had anticipated picking up exactly where she left off, but in light of the way the conversation has unfolded a little bit today, I'm gonna skip around a little bit. And I think the easiest place for me to start is Section 9 of the bill, because that's what Mr. Bray just spoke about. It's page 11. And first I want to tell you that there are some parts of criminal defense lawyers, I don't know any lawyer actually, that isn't just loving the ability to be in slippers and do court, right? We all appreciate the fact that we can do this remotely. And I also know that there are some things that that are going on in court proceedings that can be done by rule and should be done by rule, and that the Supreme Court has the ability to do by rule. And so what happens in Section 9 is, to me, they are conflating some of the things that should and would be done by rule with what should be done by law. Let's talk about what should be done by law. Subsection B, that's at the bottom of page 11, lines 267 through 269. The legislature needs to say that an oath of a witness is okay to be taken in a Zoom proceeding. I'm just going to say Zoom, but y'all know it could be Teams or WebEx or whatever. Also, I think that subsection E, which is that just because the judge is at the beach and not at his desk in the courtroom, it's still a valid proceeding. So these not physically present in the courtroom, we need that. You need to make that law. Subsection F, that it needs to be open to the public, that even though we're doing this by Zoom, that the proceedings are still considered to be open to the public. We agree that all of those subsections are necessary. But I'm troubled by some of the others. Let's start with criminal jury trials. Like you said, Mr. Chairman, you think that the words here say that only criminal trials can be conducted in person, that they can't be done by video conference. But that's not actually what the language says. And to your point, there is a case, I think it's out of Oklahoma, that says the confrontation rights, that you do have to have it in person. The confusing wording is, looking at line 270, notwithstanding any other provision to the law to the contrary. So then the reader is like, what the heck does that mean? The accused guilt or innocence. Here to tell you, juries don't determine innocence. Is to be determined unless otherwise authorized by law. So we've got these two weirdo referring us to otherwise provided by law. One could surmise that the otherwise provided by law would be court rule, and you wouldn't imagine that a court rule would say we're going to do jury trials or any kind of criminal trial remotely. But there's just a lot of unnecessary words. And I'll say, if we just say video conferencing shall not be authorized for use in any criminal trial when the accused guilt is to be determined. Something very simple instead. Then you move to paragraph 2, and I think that everyone here is thinking that this only applies to civil proceedings because it says nothing shall prevent Notwithstanding other provisions of the subsections of this code section, no trial shall be conducted remotely. To Mr. Bray's point, it doesn't say jury or non-jury. It doesn't say civil. It does allow consent of the parties. And because of that confusion, I think subsection C, we think that needs a little bit more work. With respect to subsection D, I share Mr. Bray's concern with the specific reference to Uniform Superior Court 9.2. If this remains in place, it should be a reference to any uniform rules rather than the specific citation. And then with respect to subsections A and G, I think we think that they're just sort of confusing and a little bit unnecessary, because it's true that the uniform rules control what should go on, and there's just a lot of verbiage that's more confusing than necessary. So that's comments with regard to section 9. With respect to section 7, which is where Maisie Lynn was testifying yesterday, I'm going to try to put on my best way to deal with plain error. And I want to direct your attention specifically to lines, first of all, to lines 184 to 186 on page 8, which is the new language, and then sort of contrast it with lines 196 to 198, which talks about plain error. If the bill passes in its current form, rules 103A, 3, and B would effectively be, it would conflict with D. The question is, are we going to continue with plain error as being an issue or not? Georgia was for years out of step with nearly every state in every jurisdiction, and to adopt Section 7 as it reads right now would put us back there again. The inevitable result would be a reduction of reviewable issues in civil and in criminal trials, and an increased reliance in criminal cases on ineffective assistance of counsel. I think it might help to understand what plain error is. Plain error is big as day. Everybody in the courtroom should have known that it took place, but it didn't get a ruling on it. It's the language, it's indisputably violates a legal rule that every lawyer, opposing counsel, and judge included should know about. When the adverse affected party fails to object, of course we all know they should have, an appellate court must correct the error only if the appellate court, the loser below can show a reasonable probability that it affected the outcome of the case. Courts like ours and in other states describe this plain error as a very high burden. It's a tool for correcting the most blatant illegalities at trial. It's also worth noting that plain error is already available in our code. If you look at 17-8-57 and 17-858 and the Kelly case of 290 Georgia 29, our courts first adopted the plain error test, and in many jurisdictions it allows us to it allows people to raise the illegalities from all aspects of trial. In no other jurisdictions have we found this sort of restriction or a proliferation of reversals. Prosecutors will surely complain if this gets passed that there's always this tension of should defense counsel raise the issue of ineffective assistance to counsel, or when, and when is it plain error? If the goal at lines 184 to 186 is that the appeal, if the goal is that we follow the regular appellate process when the trial court refuses to put a ruling on the record, then the language should be, when a timely objection or proffer appears in the record, a ruling by the trial court shall not be necessary to preserve the matter for direct appellate review. And I have a copy of that. I can share that with you. So we're troubled by the language on page 8, and then we're also troubled by the language on page 9 with this new subsection E. To the extent that lawyers should always file motions, all of you that are lawyers and done trial work, I'm sure have filed pretrial motions in limine. It's good practice. It makes the trial go better. hopefully you get a ruling on it beforehand. But the way this is written, this will also apply to prosecutors, that they're going to have to get a pretrial ruling on everything. The real issue is how much will this encumber and drag out trial proceedings? If this bill passes, anytime counsel interposes an evidentiary objection, opposing counsel can insist on litigating whether the objection could have reasonably been anticipated. That's the language that's used. Counties will be paying for jurors to sit while the lawyers hash out whether the lawyers on the opposing side read their discovery closely enough. So there's no point to it. Further, it departs from the long-standing practice across the country, which requires a contemporaneous objection to preserve error. And no jurisdiction that we can find requires an anticipatory evidentiary objection. So there's no reason for Georgia to deviate from that process. And of course, we're following the federal rules of evidence, and there's nothing of this creature in the federal rules of evidence.
Can I stop you when you're on that point?
Sure.
But the way it's written, isn't it more just encouraging these motions to be filed? It says should. I mean, I read the bill as more just trying to encourage lawyers to file these things versus being anything to be mandatory and not something you'd be held to necessarily. Do you read it differently?
You know, I'm troubled by that. I don't know what that means because we use may and shall. If it is truly may, then it should be the word worded may. That would probably assist. The word should kind of falls in between, and that's where the tension lies.
So you'd be more comfortable if should was may, basically, in essence.
Yes.
Okay, I'll let you. I just want to bring it
Sure.
up while you're there.
With respect to, on that same page at lines 214 to 215, so that's 103F, it's redundant of A2, which is now lines 181 to 183. So once an objection is made and ruled on, it need not be renewed, but if the new grounds arise, a new objection is necessary. The old pre-2013 code had a continuing objection rule that counsel must object to each instance of error in order to preserve it. And the only thing we can think of is that somebody must be really mad about the rules as they are now because we're reverting backwards by the language that's in this bill. I'm going to move to Section 8 of the bill, which is the similar transaction code section. It's interesting. Of course, with the drafting history that I know, I recognize copy and paste very well. And so this is copy and paste from select parts of code sections. I'm just going to call them by the federal rule numbers. It's 413, 414, all the way to 418. And interestingly, there's a provision in all of those code sections that says, this code section shall not be the exclusive means to admit or consider evidence described in this code section. It's very critical because you're looking at the rules of evidence. We ought to be looking, we have to, this really is it 404B evidence? Because this is not the situation where you have a prior conviction. This is where you're wanting to bring in other bad acts to make, whether it's the plaintiff in a lawsuit, the defendant in a lawsuit that's civil, or a criminal defendant look bad. So look over here, not really at what we're trying. This is a bad person. Don't look over here. Bad acts come in. And I'm not saying that they don't come in, but we do have a rule already. It's 404B. That's what controls. So we would ask that we would suggest that the entirety of Section 8 be removed from the bill. And if it's not removed, at the very least, it be remedied to mirror the other similar transaction code sections that are already in law. I want to circle back a moment to Section 3 of the bill. Sorry to be moving about here. Section 3 of the bill has to do with the I know you all will remember Mr. Weaver's testimony. And you all, that guy is right so many times. He's so spot on. It drives me crazy. Forcible felony is the same as what you've got here. You're just replicating the same thing. So you ask, why do you need it? Well, one of the things that you're doing differently, or this bill is doing differently, if you bring your attention to, with the stricken language at lines 94 to 96, and I'm on page 5, you can see that under current law, if somebody commits, this is possession of a firearm by a convicted felon or a first offender, if they do it, they are, the punishment is when they're on probation. They shall be imprisoned for a period of 5 years. Some of you may be familiar with the case of Langley. Clearly, the prosecutors in the state are familiar with the case of Langley. It was just decided on February 1st, where it interpreted the language that's on line 96, shall be imprisoned. You all have seen that language in the code over and over and over again. And you know what that means. Even though it says shall, it doesn't mean they must be only sentenced to prison. It means that they could get probation. They could have supervised release eventually on parole. The sentence could be stayed. What's done here is, first of all, unnecessary because you've already got the law on forcible felonies. So we're adding this other element of a definition of domestic abuse violence, which has this crazy, similarly situated to a spouse language in it, which I don't know what that means. But if you look at lines 106 to 107, they've added the language, no portion of a sentence imposed pursuant to this paragraph shall be suspended, stayed, probated, deferred, or withheld by the sentencing court. That makes it a mandatory minimum. To Senator Cowsert's point yesterday, this is just going backwards in time in terms of taking the discretion away from the very capable judges like Judge Gosling, who spends time thinking about what kind of sentence that they want to impose in a case like this. The same language at lines 106 and 107 are replicated on page 7 of the bill in section 6 when we deal with disabled persons and elder persons at lines 153 to 155, where it says provided, how this is a little bit of a different twist, but it's provided that the mandatory minimum cannot be stayed. So it's another way to go about imposing a mandatory minimum. And so at the very least, we would ask that you consider removing the language about the mandatory minimums in the bill. Let me look at my notes one more time. I think I'm close to wrapping. Thank you so much for your time. We talked about section 7, 8, 9, 3, 6. I think maybe the only other thing to point out is, although the author of the bill did discuss about all the volumes of testimony that they received about the problems that communities are having, they didn't hear from criminal defense lawyers. And these are some of the concerns that we would have shared with them in bringing forward something that of this nature. I would say also, with respect to the amendment that just was offered, let me find the language of it. You know, the venue issue, I understand the desire to bring prosecutions in as many jurisdictions as they'd like. I don't know about that word operates. Contrary to the testimony that was provided earlier, what I would do to look up the definition of operates, because I know it's not in 1615, I would ask Michael to look in the dictionary that we use, the Funken-Wagnalls, for the code, and that would be the definition that I would revert to, because at the beginning of the code it says that's the dictionary we use for the code. Otherwise, you know, this really is just if this wasn't necessary for looking for different forums to do this in, then it wouldn't be necessary to make these changes.
All right, you have a question from Senator Jones.
Yes. I had one quick question because you kind of mentioned it, but then I didn't say anything about it. That was on page 8, lines 184 through 186. On the plain error, you had mentioned about the ineffective assistance of counsel and prosecutors, and I thought I knew you was going to head with that, but can you touch on that for me?
Well, the way that you, okay, I'm trying to put on the best appellate hat that I have. It doesn't, I don't have it in the best fashion. But when you have, let's say an error has occurred where a defendant had a pretrial ruling that some evidence wasn't supposed to come in, and then it came in during the trial, and defense counsel failed to object, and the judge maybe is forgotten about the ruling, the prosecutor potentially is forgotten. It's wrong, right? It's plain error. That was not supposed to come in. Right now, you're going to have to bring that up in direct appeal on ineffective assistance of counsel. And it could be done on plain error. And the way this is conflating it is troubling.
Any other questions from the committee? All right, thank you, Ms. Travis. That's everyone that signed up to speak on the bill. I think what we'll do, if you want to, do you have a final word you want to give? Yeah, come on up. I was going to say while you're doing that, we're going to take some of these thoughts we've gotten and digest them and put the bill back on. You don't have to bring all your witnesses back. Yeah, back again, unless you just want to. I also like to see your amendment, all this put into a substitute, since we have the time to do that as well. I think it'd be cleaner that way. I'll let him have the final word, then you have some questions in the committee.
Thank you, Mr. Chairman, and I'm glad to work with you and the committee members on the amendments into a committee sub or any other questions or concerns you all have. So I look forward to following up with you. You know, in summary, we have experienced a rise in crime in this state that is untenable. We have lost way too many people's lives. We have families who have suffered great loss. There are people that are fearful. In the great spirit of what criminal justice reform was, which I proudly supported, through Governor Deal's initial initiatives, through Governor Kemp, I think Georgia's become a model for other states, and I for one, am very proud of that. I think if you remember, the very first time Governor Deal talked about that, he used these words: we have to separate those who we are mad at versus those who we are afraid of. This bill doesn't go after anybody that we're mad at, but it very much goes after those who we're afraid of. Violent crime has gone through the roof. And we as legislators have to do things to help empower our law enforcement, our district attorneys, and our judges to make sure we do the right things. It's not easy. It's a big bill. It's cumbersome. However, we also have been working on it for a good 8 months now, I think, and we have heard from literally every single interested party. And while I appreciate some of the testimony today, oversight's a good thing, not a bad thing. We have it, and we sometimes have other folks assure that they have it. But I do want to make sure we are more concerned about the victims than we are the criminals. And I think we all can agree that right now there are way too many victims, and I believe this is a good balance to get there. So, Mr. Chairman, committee members, I'd be honored to work with each and every one of you on any questions, comments, or suggestions you might have to the bill so we can perfect it and continue it moving forward on Monday.
All right. Senator Kirkpatrick has a question.
Yeah. Senator Albers, thank you so much for being willing to continue to work towards making this bill as good as we can get it. The question that I have, and this is a non-lawyer question, is what's the purpose of separating the definitions of domestic violence, felony, and family violence?
Well, I'm going to probably give you a non-lawyer
on
answer
page
then.
4.
Okay.
Line 71 through 78.
I'm going to ask Mike here, who is a lawyer, to help me with that.
One pertains to a specific offense definition, and another is a definition for the working purposes within the statute, because we do have also the evidence code provisions that interlock with some of what we have in here, so it's going to apply to those as well. And I'm certainly available also to the members of the committee here for any of the issues that were raised today as a matter of evidence, law, or otherwise pertaining to any of these provisions. Recognize you may need to move on, but that is why that appears to be why that is in this bill the way it is.
All right, Senator Hatchett has a question.
Yeah, and in the interest of time, I mean, I'm happy to speak to these after the meeting with you, but I've got a little bit of pause in Section 4 and in Section 5. Section 4, including the NOLO, just because that's not an admission necessarily, I'd like to talk to you about why that's included. I kind of want to comb over that and make sure we're getting that right. And then number 2, in Section 5, when you're saying that the offense shall be considered to have been committed in any county in which an incident of criminal game activity occurred, or in which an interest or control of a criminal street gang or real personal property thereof is required to maintain. This has the potential to mess with the venue, which is a constitutional right for Georgia citizens. And I just want to talk to you about that later, because I don't know if we can legislate around the Constitution here as it relates to venue.
2 points on that, if I may quickly, Senator. The first would be there is an amended version of this. And actually, there'll be 3 points. Secondly, there is a parallel provision in the racketeering statute which has been upheld, and because of the nature of the organizations here, because they operate in multiple counties, it allows for a venue provision along these lines to exist. Lastly, we did pull the Rodriguez case as far as the Supreme Court's use of dictionary definitions, and I would note the American Heritage, the New Shorter, Oxford dictionaries were used there in response to Gachtel's concerns about which dictionaries would be appropriate.
And looking forward to following up with you further on that, Senator.
Yeah.
Thank you.
And Rodriguez is the decision that upheld the constitutionality of the gang statute.
And in that spirit, I will encourage members of the committee to get with Senator Albers and those that have worked with him on this bill over the next week and try to get any questions you have answered so we can have a substitute. Hopefully that's something we can consider next week in committee.
Thank you very much for your time.
I'm going to call Senate Bill 360. Senator McNeil. You stayed in the room after sitting for an hour, and you're still willing to come up?
Oh, yeah. I did. Great. Thank you so much.
While we're transitioning, we'll make sure everybody's on the same page. We have LC, a substitute we're working off of, LC 490821S. So I will give you the floor, Senator McNeil, if you want to talk to us about Senate Bill 360.
Thank you to the committee for all that you do, and I was really impressed tonight with all that you have to do.
1 second. If we could please take the conversations out so we can get on to the next bill. We have 2 more bills to still consider. All right.
You ready? This issue came to my aide, who works with my constituents, and Leslie has worked with the mother of Colton from the beginning of the incident. We would like her to speak on this issue since she's been firsthand knowledge of it all. I want to say we must protect the vulnerable, and for those who cannot speak for themselves. We also spoke with our local Department of Family and Children's Services, who echoed the problems as lack of punishment for those who abuse disabled minor children and the elderly. With this said, I would like to introduce Leslie Manukian, my aide. I think most of you know Leslie.
Ms. Manukian, if you want to talk to us about your background with this as well.
I do. I got a call from a mother in her district, and it was concerning her disabled minor child. She came home, and this child had a tremendously huge bruise on his little face. Now, mind you, he has a trach and a feeding tube. He's defenseless. There's nothing he could have done to warrant.
Wheelchair.
In a wheelchair. Can't do anything. If the other child did not let her know what had happened to his little brother, she'd have never known that her live-in boyfriend had done this. She immediately had him arrested. Within an hour, he was bonded out, and he got 3 months probation. To me, this is inexcusable. I eventually had to take the picture of this child off my phone. It kept me up at night thinking, who could do this? So we talked to the local DFACS and said, does this go on a lot? And they said, yes, this is a problem that we're having. We've got to be a voice to say that these kids, they matter. The elderly, they matter. Our minor children matter enough that you have a shoplifter who gets more, a felony, you get 3 months probation and you can hit a child, a defenseless child. That's not the message that I think as, legislators you want to put forth, that it's okay. This is fine. It's not. Also, in conversation with the defense attorney lobby, because this includes negligence, we have agreed to drop the mandatory minimum requirement of enhancement. So strike the last sentence in lines 50 through 52.
And so that'll be a change you're asking us to make in the substitute, is that right?
Yes. Yes.
So my understanding when the bill was originally filed, the main goal was we didn't feel like there was a special class for disabled minors. You were treating children different ways in the code when a crime's committed against a child versus an adult, but we weren't treating a disabled minor. We're basically treating them the same way as any other disabled person. Not that any victims are being belittled in any way, but my understanding the intent was the bill was to find a way to enhance penalties when you have a disabled minor. Is that a simple way of looking at it?
I think it is a simple way, but we have also, Attorney Will Johnson, he's going to come and speak on the rest of it. I just know what this mother's been going through. I've been walking the walk with her, and I just don't see where this is right. We've got to do something better.
And that's what I was and you guys have worked with lawyers on this and with prosecuting attorneys council, is my understanding as well, and you've landed at putting this under the cruelty to children statute and having an enhanced penalty basically when it's disabled minors, my understanding. Before you go though, I'm gonna let y'all take any questions from the committee, then we'll have the other witnesses speak. Any questions from the committee for the author or aide? All right, you can sit tight. Now I will call up Mr. Will Johnson. Good afternoon.
Good afternoon. And there's not a whole lot I wanted to say on it. My name is Will Johnson. I'm with the Prosecuting Attorneys Council. I am their elder abuse prosecutor, but I also work on the disabled adult abuse as well. So while I'm not as familiar with protection of children, the disability side of it is very familiar and in my realm. When this came across my desk, I saw that it was placed originally within the elder abuse protection statute, and I reached out to look at a way to make this a more cohesive enhancement within the child cruelty statute, as well as to make sure that the appropriate statute is named Colton's Law, one that fully protects children. So I'm really just here if you have any questions on it to answer questions.
And so if somebody commits a crime against a child, we see on page 2 of the bill the current law as to how we divide up the punishment. But what this bill is doing is on page 3 is you have an enhancement when the child is disabled as well.
Correct.
We do have questions. Senator Watson?
Just want to be clear on the definition of the disabled minor. You're comfortable with that definition?
Yes. I actually drafted that definition.
Okay.
It originally was in the elder abuse protection, and it has a definition in 16.5.100 of disability, but that is pertinent only to adults. And so one of the things I wanted to do is create a definition of disabled that applies more to minors than it would to an adult.
And that relating to the major life activities and record of such impairment?
Correct. The existing one in 16.5.102 talks about activities of daily living or monetary management, and a 4 or 5-year-old is not going to manage his or her own resources. So it just was not an applicable definition to children.
So where does the major life activities and where does that come from? Is that coming from so I guess sort of what I'm getting at, is that coming more towards what's done in schools with the individual education plans, IEPs, and the 504s and things like that?
Correct. It would be something like that, or if they're unable to obtain medical markers, as you noted, I think the definition says an impairment which limits major life activities such as growth or intellectual development.
So developmental disabilities.
Correct. It would encompass both physical and developmental disabilities.
So, my wife is a special ed teacher, and so she's an expert in filling out IEPs and 504s. That's what she does. That's what she teaches, actually. So where do they fit into this?
I'm not sure I understand your question, Senator.
So in schools, that's what we use for treatment of the individual education plans and the 504s. So the IEPs, I presume, are going to have major life activities, and that sort of fits in with that. But the 504s are sort of a step down underneath that are less severe. So, in other words, are we capturing how are we distinguishing between normal variations of normal, minor variations of normal, and major variations of normal? That's sort of what I'm getting at. I want to be certain that we're not rolling this into someone that has a minor disability that maybe is in the eye of the beholder, minor versus major. So.
And I believe, Senator, the answer to that would be line 16, the substantially limits. The term substantially was pulled from the adult definition of disability, which says it's an impairment which substantially affects. And that term has been left open to the courts. So I tried to use that word as kind of a distinguishing marker that it's not just any impairment, but it's one which substantially limits the development of the child.
Yeah, that just didn't quite give me the warm and fuzzies there. So I got you. I understand.
Will that ultimately be a jury question? Would the jury have to determine what's substantially limits?
Correct, and that's what is done on the adult definition as well, as the jury determines whether this rises to the level of substantial or not.
Yeah, so a child has a 504 and his own attention deficit disorder medicines, and that's substantial. Yet there are people and children who function every day very normally on those medicines. That's a little bit of the heartburn I'm getting.
And that is a difficult question. I think, like Senator Strickland said, that would probably be a question of fact for the jury. I've had some cases with disabled adults who were 18 or 19, and they presented, you would not know that there was a disability had you sat and talked with them. But when you look at the IEP from their school, you find that higher levels of functioning are not available to them. And so that would, again, be a question for the jury whether this is a substantial enough impairment to rise to that level.
So that would be the 504 would be the one that may be on medicine and that functions totally normally. Mm-hmm. So I don't know. I just am I the only one here with heartburn over that? That's okay.
Senator Hatchett.
Thank you, Mr. Chairman. I just wanted to commend Senator McNeil for bringing this piece of legislation. I think this is very important, and for serving the people of Brunswick. Naming this after Colton, I think, is a big step, and it goes towards the biblical saying to defend the defenseless. And I want to commend you on this and thank you, and hopefully we can work all the kinks out and make sure it gets through. And I'm very grateful for this piece of legislation. So thank you.
And that's a great point. Just so you know, as you see, Judiciary Committee likes to go through every single word, but it doesn't mean we don't support what you're trying to do. And so I hope you won't take it that way. I appreciate you saying that. Obviously, we hope that what happened to this individual will bring a change in the law that will keep this from happening to other people, no matter what ultimately happens with the bill today, regardless. Any other questions right now for Mr. Johnson? All right, thank you.
Thank you.
We have Miss Jill Travis, Georgia Association of Criminal Defense Lawyers. Welcome back. No book this time, so be a little quicker.
You have no book. Thank you so much. And I did have a chance to talk to Senator McNeil beforehand. I share Senator Watson's concerns about about the disabilities. And I can't speak to that. I don't know whether that's accurate. You all make the policy. I do appreciate the predicament that these folks are in, and share the heartache that they must have experienced with having gone through an experience where a punishment doesn't seem to have fit the crime. The question then is the punishment there for the crime, or does the punishment need to be increased? And the largest concern we had about the language that's in the current draft is the mandatory minimum sentencing. I'm hoping that I don't have to keep beating that dead horse, but it is a very much of it's not a dead horse. It's very much an active concern. So taking the judicial discretion away from the judges is very much a concern of ours. And I think the author has agreed that to remove the language on lines 50 to 52, and I appreciate that. I think that, and we have also discussed the first or second degree. I mean, the one thing that you have to look at is first degree cruelty to children, no matter whether the child is capable or disabled, is currently 5 to 20 years. And so, and that includes physical infliction of pain, and one has to ask, why wasn't there a greater punishment imposed in this particular circumstance? And second degree carries 1 to 10, and those are the things that I wanted to point out to the committee.
But sitting here now, do you agree there's probably not a better way at this point to define disabled minor? No matter what we do, it's going to be a jury question, I'm assuming, regardless.
I would have to. I'm guessing that council probably looked at other places in the code where it was defined. I'm assuming in the Title 20, which I never spent much time in, there's definitions that deal with children that suffer from disabilities. I don't know if the intention of the bill is just physical disabilities, just mental disabilities, or both. I presume it's both. And I don't know the best way to say that. I do agree that it may be another issue that the prosecuting attorneys would have to prove to make that hurdle to get the 10-year punishment.
Is there any comments from Legislative Council on that part? Or you're Mike 1, right?
Yep. Only to say, yes, the physical or mental impairment, which substantially limits one or more major life activities, is a fairly standardized definition of disability, perhaps more often in the civil context under federal discrimination law and general definitions of disabled people. That's kind of the standard go-to language. And so when you start figuring out where you want to go from there, then you would probably want to get very particularized in how you would want to deviate from that broad definition, admittedly.
Okay, any other questions for Ms. Travis, or any questions for Ms. Travis? We do have a question. Senator Watson.
So let me just follow up then. So if that's pretty well established, you're saying, from a legislative council standpoint?
For the ADA, that's pretty standard ADA definition of a disabled person.
Okay, and so we're talking about major life activities. So it's probably not gonna pull in the 504s. It's probably gonna be the IEPs and am I accurate? Do you know?
In this case, I do have the benefit of being an education lawyer. You could actually be a 504 student with a very profound physical disability. The distinction between a 504 and an IEP is a student who requires an IEP requires an individualized education program because they have particular obstacles to learning. So you could have a student with an IEP who does not present as having any disability, and you could have a student who has a profound physical disability who does not require an IEP. So there really is no
I got you.
hard and fast rule.
All right, so it sounds like this is pretty standard, and so that sounds reasonable. And I mean, certainly the person that you're describing abused, I can certainly understand the enhanced aspect of that. So, all right, I'm comfortable. Okay, thank you.
Any other questions from the committee? For Ms. Travis? There's no one, thank you. There's no one else that's signed up to speak on the bill. What's the pleasure of the committee? Senator Kirkpatrick.
Mr. Chairman, at that appropriate time, I'd like to move due pass.
This is the appropriate time. You move in due pass by committee substitute
Yes.
LC 490821S.
That's the one.
Do we have a second? A second from Senator Parent, a motion from Senator Kirkpatrick. Do we have any amendments?
Yes, Mr. Chairman.
All right, Senator Hatchett.
I would like to get the author's opinion of the proposed amendment, which is striking the last sentence on line 50 and 52.
So you be
okay. I'd like to propose amendment to strike the last sentence beginning with no on line 50 and ending with court on line 52.
Some of the author is in support of. Do we have a second on the amendment? We have a second amendment from Senator Hatchett. Legislative Counsel.
If I may, Chair,
Please.
if we could just have then the conforming change in the title of the bill, which would be on lines 4 through 6, which refers to the same provision. So if we could strike from following minor semicolon through court semicolon.
Does everybody understand the amendment? Senator Hatchett, will you accept that as your amendment?
Yes.
Any questions on the amendment or discussion on the amendment? All those in favor, please raise your hand. We have 7 unanimous. All right, the bill has now been amended. Do we have any other amendments? Senator Watson, do you want to be recognized?
No. Sorry, apologize.
Do we have any discussion on the bill? All right, at this point, we have a motion due pass by committee substitute as amended. All those in favor of the motion, please raise your hand. We have 7, none opposed, passed unanimously. You're now on to rules. Thank you. All right, we have one last bill on the agenda, if y'all can stick with us. We have Senate Bill 354. Senator Rett, you're welcome to sit there. You can go down, whatever you're more comfortable with. You want to come down?
I'll go down.
All right. It's a hot seat tonight, but they're batting 500. And we are also working on a substitute, LC 471579S. Is that correct?
Yes, sir.
All right, Senator Rett, the floor is yours.
Thank you, Mr. Chairman, fellow senators, colleagues, friends, and y'all. Today I want to talk with you about Senate Bill 354. And what it does is require municipal corporations to provide notice to all electors before a public hearing on any application for annexation. Currently, Georgia law provides the procedure for municipal corporations to annex unincorporated areas contiguous to existing corporate limits. requiring, among other things, written and signed applications of all the owners of all the land, except owners of public street, road, highways, or right-of-way proposed to be annexed. Additionally, Georgia law requires municipal corporations to hold a public hearing on any application for annexation. The notice of the time and place of the hearing must be given in writing to the persons presenting the application and must be advertised once per week for 2 consecutive weeks immediately preceding the hearing in a newspaper of general circulation and a municipal corporation and in the area proposed for an annexation. Basically, this bill, all it does is it requires the municipal corporation to provide notice by mail to every elector on the list of electors compiled by the County Board of Registers. The reason I came up with this bill is last year, the city of Austell wanted to incorporate some areas that are unincorporated within the city limits. It made it through the House, but when it got to the Senate, we found out that the people they wanted to annex had never been contacted. So we ended up having to table it. And the problem there is you can get a group of people of 100 people and get them in a room, and they say, yeah, we're for this, but have you reached out to the other people who may not have an interest in it? And that's how I came up with this bill. I'm open for any suggestions. If you have any, let the good times roll.
I have a question on the process. So the current draft of your bill, the way I'm reading it, so the 60% of electors who sign asking for the annexation, I'm assuming they're signing some sort of document that's submitted to the city.
Yes, that's
and
correct.
And I'm sure GMA will correct me if I'm saying this wrong, because I may be. At that point, then the city, under your bill, would have to take the people that signed that document and submitted their names and send them certified mail. It doesn't say certified. Send them mail, notifying them of the hearing that's going to be held on the annexation. Is that right?
60% of the elected residents in the area, including also the 60% of the landowners. It's not necessarily to that group of people who signed up saying they want this. You have to notify 60% of the people in that area. Just like the example I gave, they never contacted the people at all who lived there.
Right.
So basically what we want to do is contact the property owners in the areas. Sometimes it's easy to get a list from the Board of Elections to find out the people who live there, and make it a point that you try to contact them about this. Because a lot of times in these annexations, they only contact the people. Well, if I got a list and I need to get a certain percentage, heck, I'm going to go to the people I know are going to say yeah.
Right.
But did you ever go notify the people who said no? And then all of a sudden, they see on the ballot, hell, we're up for, excuse me, we're up for a cityhood and no one even told us.
You know, just file a bill and let the people vote on it, I guess, after the fact. People do crazy things.
But sometimes it's good to make sure you consult everyone, because in that case I gave, what could have happened is if we had said, okay, yeah, you can have a vote on this and become a cityhood, then people would say, no one contacted us, and why is the legislature getting involved in local business? And we never even contacted the people who you're trying to annex.
My fear of it, though, the way I'm reading the bill, unless I'm missing it, is the way it's written, you'd only be sending mail to those that asked for the annexation. Am I reading that wrong?
No.
Okay.
Basically, from my understanding with legislative council, this would go to the people in the area that you're annexing.
Okay. Every elector would be everybody.
Right.
Okay.
Every elector listed on the list.
Okay.
Reference 3632, that's the list that they're referencing, a list that the Board of Elections has, and it's
every elector in the affected area would
Right.
get the mail.
That's correct.
That's one question. I'll turn it over to the other. Is there a reason?
Did a legislative council want to weigh in, or did you have?
Is that correct?
That is correct.
Okay. Is there a reason it just says mail and isn't certified mail? How do we? know if it was sent.
Well, there's different forms of mail. There's one in particular that the municipalities use, and that's called, give me just a second here. That's called, I got it written here, certificate of mailing. And because, let's say you got 50,000 people, and you talk about sending certified mail or registered mail, that's what, $7 a pop? That's a lot of money. But what they normally do is they use what they call a certificate of mailing to notify people. And what it does is provide evidence that you sent an item when you said you did by mail, and this is an official document that you get. The post office stamps that you actually sent the mail out, showing that you made an attempt to reach the people in the area. And municipalities use that all the time, and it's less costly, but we're just trying to find a way to make sure that everybody involved in this situation are notified or need to be notified, instead of just getting a group of people and saying, hey, well, we got all these people who say, yeah, so they sign on the list, let's do this.
Or we have questions of the committee. Senator Kennedy.
Thank you, Mr. Chairman. Senator Rhett, good to see you. And for the benefit of the committee, Senator Rhett and I have worked on this a little bit. He brought it to me, and I had expressed some concerns. And I think my concerns are still here, but they're on a different topic, I think, than what we've talked about. But I need legislative counsel to help me a little bit. And my question, Mr. Chairman, if I may ask legislative counsel, is under the law as it's written, is notice required to be given to the electors of the area proposed for annexation, or is it to the owners of the property being proposed for annexation?
Because the code section says residing in such area.
I apologize, Senator. I'm sorry, but I don't understand the question.
What's that?
Yeah, you want to ask your
Okay,
question?
yeah. So the notice requirements that are in law right now that have to be provided related to annexation or proposed annexation, do those notices go to the owners of the proposed property or occupants, such as tenants? I mean, I'm reading the term electors to mean those that are what, registered voters in the area to be that's proposed to be annexed. Is that right?
The notice requirement in existing law is a public notice advertised in the local public newspaper.
Can you help?
Senator Parent.
If I'm not mistaken, I think the question you're asking is to get to the 60%, are you talking about property owners or are you talking about electors?
Yes. Yeah.
Yeah, the notice requirement's pretty clear because there is no notice mailed right now. So the question is, what
thank you.
constitutes
Yes.
a 60% annexation?
Yes, I think thank you. That helps, I think, frame the question.
But isn't that defined under Section D? Because it's a list that's provided by the registrar. And so would it just be whatever that list that's compiled, and it says resident, it says residing, but I guess you'd rely on the list that's provided?
And if I could, Mr. Chairman, my concern, and maybe my concern is out of step with what the law is now, so that's why I'm phrasing the question this way. To me, to engage the public, let's just say the public in general, about a proposed annexation, ought to be engaging the property owners, not tenants or other people that don't have a property interest in the subject property. And that's what Senator Rhett and I have talked about that in the past, but it may be that the law requires some sort of engagement with non-property owners or those that have no property interest in the subject proposed property anyway, and that's why I asked the question. I may be behind the times on that already.
Legislative Council.
My on-the-fly reading here is that the process involves the application by 60% of the electors resident in the area included in any such application, and the owners of not less than 60% of the land area by acreage included in such application. So then the list that's being referred to is compiled to make sure that the 60% threshold is met. So you have your people who have applied for the annexation, and then the duty is imposed to get a list of everyone to make sure that your applicants have met that 60% threshold. And then that list is what is the list that is referred to in the new language, that the mailed notice would go to everyone that is on that list.
Does that answer your question?
I think so.
Senator
The list would be the list of electors residing in such area.
And that's current law now.
That's
so
current
I think
law.
what you're informing me of is that there's that notification requirement and the 60% threshold issue that's already in the law now for the electors of the area. And then you've got a separate track where you have to meet the percentage threshold for the owners of the property as well.
The 60% is for in order for the application to move forward, it has to be supported by no less than 60% of the electors resident in the area. But then the way that you confirm that you have reached that 60% threshold is to compile a comprehensive list of the electors residing in such area.
Maybe they won't send Judiciary any more annexation bills after this. Senator Parent?
I thought the 100% method was property owners. So to clarify, does that mean that both, and I'm trying to remember because I think I knew this at one point, both 100% and 60% method requires you to get that proportion of the property owners and of the voters, or are the electors the property owners? I think it's the property owners. And I think it's voters when we do it, when we do a legislative and then it's on the ballot. Then it's voters, right? You just have to get 50% or whatever we put in the bill of the voters. But I think when it's 60 or 100, it's property owners. And so the electors would be property owners in this instance, I believe. But we probably should find out for sure.
Yeah, I think it may be helpful if we had somebody that's, because there's all different, it was another question about different methods of annexation. There's different ways you annex. We're not used to this type because this is not a legislative annexation that we're used to. This is a different way where property owners can basically force an annexation. Maybe we need for the next hearing, Senator, to get someone that that is an expert on this area of annexation. None of us really are. It's not something we deal with typically in this committee either, that can maybe educate us a little bit about the process as well.
I guess the question is, who would that be?
I have a law partner that might be willing to do it. I don't know. Representative Welch used to do this when he was here. He's the only person I know that knows this stuff.
And I appreciate Senator Kennedy's suggestion on that, because basically I think you want to focus on the property owners in this case. But I guess we got to figure out. I'm sorry, what you?
Perhaps, Mr. Chairman, someone in legislative council that maybe has some expertise in
Yeah.
this field.
Whoever staff's logo.
Slogo, there you go. Senator Kirkpatrick?
Yeah, just one other question. I guess mail is still the standard for notification as opposed to any other electronic means, for example? Because we're moving into less snail mail and a lot of things, so. But is that the standard for notification for when a city wants to notify people?
Yes, because basically a lot of people don't necessarily have access to internet. And then there's a way but this way they can verify that it's going right to, because the internet, you can send it an email or something, but you don't know if it's going to the property owner or not. But basically, through mail, you have an address, you can send it there, and it's on record. Makes it a lot easier.
Thank you, Mr. Chairman. So then if the mail comes back, they've done their duty by just sending it
the
they've
first
done their
time.
due diligence to make an effort. Because, a lot of people drive down the street and see a yellow sign, a zoning sign or something else. Don't pay attention, but then all of a sudden they call us and say, hey, I didn't know they were building this next to, my property.
And the one thing I'll say that's a little bit of a slippery slope, I always hate those arguments, but we have things such as the way we give notice of legislation by putting things in a legal organ that most people may not read anymore. You have ways cities advertise hearings now that are set up by law. And so this does set a special class where now we're going to start mailing things. And I don't know if that's a step forward or a step backwards as far as giving notice. I get what you're trying to do, but it's also an issue we have in lots of areas in our law where it's hard to give people uniform notice of things that are coming up. So that's just a general thought I had in looking at this. But any other questions from the committee for the author at this time? All right, we'll do some homework on it then and see if we can figure out the best way to do this.
Yes, sir.
All right, that's everything we have today. With that, we're adjourned.